Hi, Robert Wareham from the Law Center, continuing our video series on House Bill 19-1177 regarding extreme risk protection orders, otherwise known as the red flag bill. In our last segment, we talked about basically the evidence and the factors the court is to consider at the hearing, which is mandated within 14 days, but again, no minimum time, so the court could require the respondent to show up a couple of days later. So at that hearing, the statute provides the court will examine under oath the petitioner, the respondent, and any witnesses they may produce, or in lieu of examination, consider sworn affidavits of the petitioner, the respondent, and any witnesses they may produce. How does cross-examination come into play if we're allowing the petitioner to, in essence, appear at this hearing by affidavit? It's a very unusual thing and would appear, again, to violate provisions of the United States Constitution that allows you to confront witnesses against you. The court can request a background check from the Colorado Bureau of Investigation, and they can review that. So again, remember that long list of possible crimes that the court could consider? They can pull up any of that. And remember, the statute did not require convictions for those crimes. The statute, the Extreme Risk Protection Order statute, requires arrest, the court to consider arrests where the charges may in fact have been entirely dismissed against you. The court shall allow the petitioner and respondent to present evidence and cross-examine witnesses. Rules of evidence apply to the same extent as with a civil protection order. And during the hearing, the court shall consider any available mental health evaluation or chemical dependency test. Now, if I was handling one of these as a legal practitioner, that would be probably the first thing I would do, is try and get the respondent in to a mental health professional to undergo some sort of psychological evaluation, because I frankly don't know what it means to pose a significant risk. We deal with the term imminent danger a lot, but this doesn't require that. There's no requirement or of the imminency, if you will, of the danger that's posed here. It's just a significant risk. Now, before issuing an extreme risk protection order under the bill, the court is also to consider whether the respondent meets the standard for a court-ordered evaluation for persons with mental health disorders. In essence, that's what we refer to as an M1 hold, which has been available to law enforcement all during this. Law enforcement can go out, pick up a person that they think is exhibiting mental health disorders, and they can actually have them physically committed for 72 hours. Now, once the 72 hours is up, then a mental health professional would have to basically file paperwork with the court for an involuntary commitment based on the fact that the person was a danger to themselves or others, or was gravely disabled. So let's assume now, for purposes of argument, that the court listens to this and decides that there is not clear and convincing evidence that the person poses a significant risk to themselves or others. Well, if that's it, then it's over right then. And in fact, the statute does provide that if there were weapons surrendered, those weapons need to be returned to the respondent promptly. Any notice of the temporary extreme risk protection order must be removed from all state databases. And if the person surrendered their concealed handguns permit as a part of having the temporary extreme risk protection order issued, then that concealed handgun permit is to be reissued. It's a requirement the sheriff shall reissue the concealed handgun permit to the respondent at that time. But if the court determines that there is clear and convincing evidence that the respondent poses a significant risk to themselves or others, then the court shall and is required to enter an extreme risk protection order. And for purposes of this, I'll call it the permanent order, but the order is limited to 364 days, just under 1 year. I don't know what the logic was of 364 days, but that's what the statute enumerates. It says the court shall issue an extreme risk protection order for 364 days. Now whatever firearms have been relinquished, whatever concealed handgun permits have been relinquished, those will remain relinquished or confiscated, is probably a more accurate word, by law enforcement for the duration of the extreme risk protection order. And again, the respondent can indicate a preference to law enforcement to either sell the weapons or place them in private storage with a federal firearms licensee in lieu of having them held by law enforcement. And the statute does say that the weapons are to be maintained in substantially the same condition. So I think it does create sort of a duty of care for law enforcement when they're doing this. So now the extreme risk, the permanent version of the extreme risk protection order has been issued. The respondent at this point, assuming for a minute that they didn't have really time to get psych evals or to assemble their defense, and so they come in there and they're not successful in defending against the extreme risk protection order, now it is made permanent and in effect for 364 days. The law provides that one time during that 364-day period, the respondent can again ask to have the extreme risk protection order terminated. Now, I assume the assumption of the drafters would be that maybe at the time the extreme risk protection order was being issued, the person was going through a difficult time, or maybe they had started some new medications and it was having an effect on them, and that perhaps following the extreme risk protection order sometime after the 14-day hearing, they got their meds rebalanced or life circumstances changed, and so now they no longer pose a risk and they're able to come forward with a psych eval. And I can tell you, if I had a client who had had a temporary extreme risk protection order made permanent at the 14-day hearing, and they came to me seeking to have that order terminated sometime during the 364 days, I would be insisting that they undergo a complete psychological evaluation. Keep in mind, attorneys don't work for free, psychologists don't work for free. Someone who is going to defend against an extreme risk protection order is probably going to be looking at legal fees and mental health professional fees somewhere between $7,500 and $10,000 by the time they make it to that next hearing, perhaps challenging the extreme risk protection order that was made permanent. Now, at that additional hearing, there is a very troublesome thing, and that is the burden of proof is shifted to the respondent. In other words, once the permanent extreme risk protection order enters, the one that is for 364 days, this legislation takes the very bold and unusual step, and frankly offensive step, of shifting the burden of proof to the respondent. So now we have a law-abiding citizen, again, no crime necessarily has been alleged here. So we have an otherwise law-abiding citizen that someone has accused of being a little different or having a mental health issue, now put in the position of being forced to prove by clear and convincing evidence that they are entitled to exercise a fundamental liberty right. We don't require this of anyone else in any other situation, requiring a respondent in a legal action to prove that they should be allowed to vote, that they should be allowed to get married or have children, any of these fundamental liberty issues. We don't shift the burden of proof to them. The burden of proof remains on the petitioner, but that's a very unusual thing. Now, what the court can do at that additional hearing, they have to hold it as well within 14 days of the request coming in. And what the court can do is, if they're looking at it and the court is sort of unsure and thinks, well, maybe I'd like to see a little more progress, because the respondent is limited to only requesting termination one time during the 364 days, what the court is empowered to do through the legislation is to say, I've heard your evidence. I think maybe we need to see a little bit more progress, and so I'm going to continue this termination hearing out another 2 months. Maybe it's held 6 months into the ERPO. They could continue the hearing another 2 months. But of course, it would make no sense to continue the hearing beyond the expiration date of the extreme risk protection order. And that is a facet of the bill. When a temporary emergency, an extreme risk protection order is, I'm going to stop there, we're going to edit. That's another facet of the bill. When a temporary extreme risk protection order is issued, it actually expires on the date set by the court for that 14-day hearing. So if on April 1st, an extreme risk protection order enters, the court orders a hearing on April 12th, literally that temporary extreme risk protection order does expire on April 12th unless the court finds by a preponderance of the or by clear and convincing evidence that a significant risk does exist. Then the 360-day order, 364-day order goes into effect, and by its terms, the order expires at the end of that 364 days. In our next segment, we'll talk about the prospects for renewing or just expiration under its own terms of extreme risk protection orders.